Hi everyone, this is Nicole Snyder and I'll be your speaker today. I think I know a few people are still logging on and joining, but it's a little bit after the hour, so I think we'll go ahead and get started with the webinar today, which is Healthcare Mergers and Acquisitions. A little bit about me. I am a partner at the law firm of Holland & Hart, where I practice corporate law and mergers and acquisitions, especially in the healthcare industry. You can see my contact information on the slide, and I would love to connect with anyone who's joining today on LinkedIn. There's my LinkedIn address if you'd like to click on and send me an invite. I've been with Holland & Hart for about 18 years, and I regularly do mergers, acquisitions, day-to-day corporate and business issues, and I also do transactional employment law, such as physician employment agreements and wage and hour issues and counseling that comes along with business operations. So I'm really excited to be able to speak with you all today and talk about what is truly a hot topic given where the industry is. I'll start by giving you just a brief overview of the topics that we'll be covering today. We'll start with an overview of the market. Then we'll talk about sort of the most recent and most interesting trends in healthcare M&A that are happening this year. Then we'll jump right into structuring the deal. We'll do structuring the deal for compliance, which I think is sort of the main issue when it comes to healthcare M&A. And then we'll move straight to structuring under traditional M&A concerns, so valuing and structuring the deal. We'll jump into tips for negotiating so that there can be some takeaways from the webinar today, especially with the letter of intent, and then some of the key issues with purchase agreements. And then, as stated in the invitation, we're going to cover some key employment and benefits issues that are often front and center in any other M&A deals that come along. And then we'll talk a little bit at the end about integration plans for the post-merger, the post-acquisition world. So let's start out with, I should say one housekeeping thing too. If anyone would like to type questions, I can see them. I'll probably respond to them afterwards, but they will stay up after the webinar concludes. So feel free to type questions in online, or of course you can always contact me through my contact information and I'd be happy to respond. So let's start with an overview of healthcare M&A. Obviously, the name of the game, as most people understand, is that consolidation has continued. M&A activity grew between 70% between 2010 and 2015. 2015 was actually the peak year, but what we found was it wasn't a peak followed by a valley. It was a peak that was an all-time high, but what has happened is the M&A activity in healthcare continues to be very strong. We're seeing close to 1,000 transactions a year, which is very significant. So, you know, what's driving all this? I think there are probably 4 things that I would say are at play. Of course, we have the age-old pressure from both the government payers and the insurance payers to lower costs, so that's forcing consolidation in the market. The cost of technology and the investment in technology and the need to keep up with technology is certainly causing a drive for practitioners to consolidate in one way or another and share their resources. The economy generally is probably the third factor. There's increased M&A activity nearly in every industry, so it's not surprising that healthcare would be right in there with all the others. When we have a strong economy, we generally see a lot of M&A activity, and then it's especially spurred on by what I would call the fourth factor, which is low interest rates, at least relatively speaking. That really helps drive M&A activity in any sector. As for trends, some of the things that we're seeing a lot lately, I'd say 3 things. One is the CINs, the clinically integrated networks. This is, of course, not really a traditional merger or change in control or an acquisition, but rather it's integrating various providers into a network to get some of those cost savings. That's happening just because they're getting more normal, more recognized. It's also, there have been some new clarity under the antitrust laws by the Department of Justice. There's obviously going to be tons of focus all the time about antitrust in the healthcare industry, but CINs have received some guidance lately that makes them able to operate with a little less risk. The second one is traditional consolidation, of course, just groups under the same legal umbrella. So whether it be, you know, a nationwide corporate provider that owns various practices, or simply various groups combining under one umbrella, just sort of the traditional continues. And then the third thing is really private equity. And we're seeing more and more private equity in all kinds of M&A activity, but the healthcare is definitely not immune from that. We're seeing that especially in long-term care, such as nursing homes or other care facilities, also medical devices, the technology sector where it intersects with the healthcare. Private equity is a big trend that we're seeing in the healthcare M&A. So let's jump right into structuring the deal for compliance purposes. And I want to go through 3 steps here that I think really precede even a discussion of how what you would see in another industry, which is you would jump right into tax, and you'd jump right into should it be an asset sale, stock sale, a merger, or something else. With healthcare, it's really different, which is you go through what is really a compliance analysis. So step 1, I'll call the CHOW analysis, which is the change of ownership analysis. And really what that consists of is looking at the regulatory requirements that require approvals, consents, or notices. It's really, really critical at this stage to involve a healthcare attorney who knows their stuff. If you screw this up, it could, I mean, best case, it kills the deal. Worst case, you end up with an entity that can't practice, and I guess maybe even beyond worst case is civil or even criminal litigation for violating some sort of healthcare regulatory provision. So it's really, really important to get this right. You can do a fair amount of anonymous inquiries to regulators, but again, I think at the end of the day, you really need to have a healthcare expert who's driving the structure to make sure that the resulting entity after the transaction concludes is an entity that can operate legally. Another important point here is that regulatory notices and consents often have to be filed 120 days before closing, so that puts a real time frame around the transaction, and that's a challenge, quite frankly, because as everyone knows, 120 days in a merger and acquisition of any kind is something that can lead to deal fatigue on both sides. It can lead to cold feet. So trying to make sure that that time frame doesn't get any longer than it needs to be can be really important, and you don't want those long notice periods popping up at the last minute and being hit unaware with them. Step 2 on structuring the deal for compliance is the federal anti-corruption and fraud laws. So I think that this is really important for 2 reasons, 2 things to think about here. One is just the structuring that we're talking about here, but 2 is starting to think really early about the diligence, because you have to structure around the federal anti-corruption and fraud laws, but then any entities need to be thinking about success or liability and what liabilities they might be taking on with regard to the other party's possible regulatory violations. So when you're structuring it, well, there are 2 things to really big picture keep in mind, and given the time frame that we have today, I won't go down into the details on any of these, but you know, there can generally be no payment of remuneration to induce or reward patient referrals, and that goes to both how has this entity been operating pre-transaction, but it also goes to how are we structuring it and how is the compensation going to work, and is there an earn-out or something that can potentially violate the federal anti-corruption and fraud laws. So trying to steer clear of any of those problems is really important. The second part of this is no referral of patients to entities which the provider has a financial relationship for services payable by Medicare or Medicaid. This is a really big diligence issue. You can always have the seller or the merging, the non-survivor rep and warrant that they have no violations, but of course that may be of no comfort depending on the level of liability and the fact that there may not be a deep pocket to go back to if that's violated. So it's a really important diligence piece that any buyer or survivor should be looking at before they link up with the other entity. Similarly, of course, if you're structuring, then you want to make sure that you don't have entities that are by their nature referring patients in violation of the Medicare and Medicaid rules. Step 3, under structuring the deal for compliance, is state laws. Really important to remember that we are a country of 50 different states and quite literally 50 different sets of laws that regulate the practice of medicine and licensing of any business, but especially of healthcare businesses. And you have layers and layers because you have the state, and then you have the licensing boards of each state, and then you can have even nuances on top of that depending on judicial circuits and how they've interpreted different laws. So it's a really big challenge to overcome in trying to structure a deal to make sure that it complies with all the various states that might be implicated by the time that you consolidate various different organizations under one umbrella. The corporate practice of medicine is still a law that is alive and well in many states. And what the corporate practice of medicine is that you cannot have, in some states, you need to have only individual licensed providers owning healthcare organizations. You can't have it owned by a corporation. So that is still something that can be a stumbling block, I guess, to different structures when you're structuring a deal for compliance. Similarly, non-compete laws can come into play because a lot of mergers and acquisitions are sort of driven by the concept that the resulting entity will be able to hang on to the majority of the providers, and perhaps, too, that the majority of the providers will then be locked in as a result of signing something at closing, whether it's an employment agreement or something in connection with the sale document that would prevent them from then leaving later and competing, which would obviously destroy the value that the buyer is paying in the deal. So non-compete laws become very important, and there are some states like California where non-compete laws are just generally prohibited in nearly every form. There are other states where they're prohibited by local licensing ethics rules for the practice of medicine, so those have to be navigated. But that's a really important one to figure out if the providers are a key component of the deal, which they typically are. And then, of course, there's other licensing issues that can come into play that are general business issues that should be thought about. So lots to think about when it comes to structuring the deal for compliance. Let's turn now to just normal, I'll say normal, valuing and structuring of a merger or an acquisition deal that is not necessarily unique to the healthcare industry, but key nonetheless. Once you can get past those compliance issues and understand how you can structure and what that NA can look like, now it's time to mesh that up with whether this is going to be an asset sale, a stock sale, a merger, a joint venture. And that analysis, in my mind, is really driven, one, by compliance, which we just covered, but then two other things. Number two would be tax considerations, because that really drives so much of the economics of a deal. So first you are wading through the compliance, and then you're marrying up your compliance with really the tax considerations. And then finally, the liabilities become a consideration, because there are different liabilities that can be cut off or live on depending on whether you choose an asset deal or a stock deal. So when it comes to valuing the practice, though, the sources really are industry data, service provider data, and then brokers. So if you're engaging brokers or bankers, then there's a lot of data out there. Obviously, if you're talking about anything approaching public company, then there's really good data. It's harder, but it comes out in sort of the industry publications and people who are in the industry who aren't bound by confidentiality agreements to share information. The three types of valuing a practice are market approach, which is using comparable data if it's available, the income approach, which is projecting profits into the future, such as a multiple of EBITDA that someone might pay, and then also the asset approach, which is just assets, doesn't account for goodwill. The asset approach is what's going to happen if you're buying a practice that the providers are unlikely to be around for a long amount of time, if you're consolidating a group of practices that have perhaps retiring physicians, then you'll see a much bigger emphasis on asset approach over something like an income approach where we're talking about EBITDA. So a few practical tips on valuing and structuring the deal. The seller tips are really, of course, educating yourself about the various practice valuations. And, you know, if you can get a evaluator that operates in the industry and can give a good valuation of the practice, that's really the best way to go. And there are certainly a number of them that's all they do. And specializing in the healthcare industry, I think, is really important if you're going to go out and pay $10,000, $20,000, $30,000 for a really good valuation, you're going to want to have someone who is used to valuing healthcare practices and being able to provide comparable data so that you get a really valuable valuation. A seller will typically want a stock sale as well. It provides the ability to transfer residual liabilities because liabilities typically go with a stock sale as opposed to an asset sale. It may, in a lot of cases, allow better tax treatment, and it can make license transfers easier in some states, although that's one that dips back into the regulatory realm. And of course, it's really difficult to say based on state by state whether that will actually be true, but it is a lot of times, especially with the general business license and other things that go along with a healthcare practice. And also, stock sale can make contract transfers easier, particularly if you're buying facility leases. Because if you're doing an asset sale, you are 99% certain that you're going to be going to a landlord to ask for consent to transfer that lease, whereas if you do a stock sale, there's a far better chance that landlord consent isn't going to come into play, and you're not going to have a landlord who's holding the deal hostage. The buyer tips for valuing and structuring the deal, a buyer will typically prefer an asset sale, sort of the mirror image of just what I talked about for advantages of a stock sale for a seller. The buyer likes it because it provides the ability to minimize the assumption of residual liabilities, although not all, because successor liability in the healthcare world is a real thing. There are certain areas of the law where you cannot wipe out all liabilities. Environmental law is one of them, and healthcare liabilities, certain ones of them can still be assumed by the buyer. So there's some of this, and you can certainly take the general business liabilities and say that an asset sale is typically going to be better than a stock sale. But not all. The other things, though, if you're the buyer and you're doing an asset sale, you can typically do more depreciation on taxes, and it also provides advantages in financial reporting if there's some larger corporate consolidator that's backed by private equity funds, and that can be a real consideration. Let's move now to the letter of intent. And I know that when it comes to doing a deal, a lot of times people jump right to the purchase agreement and think that's the most important thing. I have a contrary view. I think that the letter of intent deserves as much time and effort nearly as the purchase agreement, because there's so many things that could derail a deal that if everyone can get those things settled in a letter of intent on the front end, and it can sure make the odds of a deal going through a lot better on the back end. This is also the time you can use to be doing your compliance structuring and your tax structuring and make sure that's all ironed out. So I think it's worthwhile spending a ton of time on a letter of intent. Quite honestly, again, more important in some ways than spending time negotiating the purchase agreement, which is obviously much longer, but it all goes so much more efficiently if you can iron a lot of these things out in the letter of intent. So what would be minimums for covering here? Obviously structure, the price, the form of payment, the assets and the liabilities being transferred, management after closing, including, I would say, terms of employment agreements. A lot of times letters of intent will sort of blindly say, oh, and the closing is contingent on these providers signing employment agreements, but doesn't talk about the terms. I would say, to the extent possible, if you can iron those out on the front end, things will go much more smoothly, because that could be a real trip up when someone has the ability to stop the whole deal because they don't like the employment deal that they're being offered. The due diligence period should obviously be specified, and then if you are the buyer, then you want to insist on exclusivity so that the seller can't be shopping the deal while you're negotiating. Here are some, what I hope are some practical tips if you're negotiating a letter of intent that you might be able to use. If you're the seller, then here are some of the things that you want to make sure or you want to try to negotiate in the deal. First of all, no adjustments to the purchase price during the due diligence or the post-closing. So, you know, what typically happens is you sign a letter of intent, then you go to start negotiating the purchase agreement or you sign it, and then there's this due diligence that's ongoing. What you would really prefer if you're the seller is that that doesn't start a process of the buyer coming back and adjusting. So if you can lock into a purchase price, that's much more helpful. Second, seller would always like cash at closing, so no escrows, no holdbacks, no earnouts. The more you can get up front in your pocket at closing, the better. A seller should look for minimal buyer escape clauses, and what I mean by that is once you've gone through the trauma and drama of negotiating a full purchase agreement and then sitting through the due diligence period, you really want to have minimal ways that the buyer can say, nah, deal's off and I want to leave, because at that point you've gone through a huge hassle, and so if you can lock them in the agreement so that the buyer can't walk, that's really important. Seller tip number 4 there in the bullets is employment and management terms. Again, the importance of trying to nail those down so that you can't have an individual or individuals who hold you hostage as you try to close the deal. Negotiating a lease assumption is really important, and it's not uncommon to have a lease literally ruin a deal when it's a big part of a practice, for example, and then you've got an unreasonable landlord or a landlord with different goals who uses this occasion to say no to the transfer for whatever reason, either to try to get more money out of the deal or just to end it and move on to something that's more profitable for them. So negotiating that lease assumption on the front end is really important. And then a seller should probably try to minimize their role in the integration process, unless, of course, the seller is getting paid as a result of earnings afterwards, and then in which case the seller may want to control a lot of the integration process post-closing. Buyer tips on the letter of intent. So the buyer tips are you want a maximum purchase price and then due diligence adjustments downward. So when you find the holes and you find the warts and everything else in the due diligence process, you want sort of a built-in automatic downward adjustment to the purchase price if possible. A buyer would also want a deferred purchase price with a balance in escrow, or better yet, not in escrow, but that's pretty unlikely to happen. So a buyer would love to pay as much of that purchase price as they can with a promissory note, putting the balance in escrow and then only having to release it upon satisfaction of the conditions, and being able to draw from reps and warranties and breaches right out of that escrow instead of having to go pound on sellers who may have taken their cash and spent it. A buyer would also want generous buyer escape clauses. So the ways to accomplish that if you're the buyer is to say that the deal is subject to board approval or general satisfaction with due diligence. A seller with bargaining power will say no way, because they will recognize that board approval is nothing more than the ability to say no at any point prior to getting to the altar. But the buyer would love to have that in case things don't come through and for maximum flexibility. And then the buyer really should, from day one, begin integration planning, because the way that the buyer can get value out of it is trying to figure out how they're going to make this run afterwards. So, to the extent that they can start building in that letter of intent, how they're going to do the integration planning and what that's going to require pre-close, that's really important and should be dealt with right up front. So let's talk now a little bit about the purchase agreement. And the purchase agreement is, of course, a definitive sale agreement that sets forth all the terms of the deal. It has all of seller's representations and warranties. It has all of buyer's rights to recover if there's a breach in the representations and warranties. It has employment terms. They can be in exhibits and employment agreements, of course. They deal with the facility lease, the purchase terms, all the post-closing responsibilities. So this is the ginormous document that gets negotiated, which, as I said, can go much more smoothly or much more slowly, depending on how well that letter of intent's been hammered out. I'll go through some tips, and I guess I should caveat this with saying, we could spend literally an entire day or two on purchase and sale agreements, and especially with all the regulatory issues. So I'm hoping that this webinar is practical and it can give you something to take back and say this is what we should do if we're negotiating. So I'm going to try to give you things that you can take, but this is not down in the weeds on every provision, obviously. But let's jump right in. So seller tips. If you're the seller and you're negotiating the purchase and sale agreement, what you really want is you want limited seller representation. So you want to push as much of that diligence responsibility onto the buyer and say, buyer, you're looking at it, you're deciding to buy, you're relying on your own due diligence to price this deal, so I'm going to make limited seller representations. This goes directly to the pricing of the deal, so you will find buyers saying, no, you know, I priced it as a multiple of earnings, and the reason I did so is because I thought I was buying a near-perfect company, and so I want all these reps and warranties that show me that it's a near-perfect, meaning financial statements are in good shape. There's no claims, there's no hint of problems. You've classified your employees correctly, you've done everything right under the sun, and that's how I price this deal. It really goes to the fundamental, how did we come up with the purchase price? But if you're the seller, you're pushing back. Similarly, if you're the seller, on bullet number 2, you want a limited term of survival on the seller representations. So what I mean by that is the seller is going to say in the deal, okay, we're making all these representations and warranties about the state of the business that you're buying, but you, buyer, have X amount of time to come back and claim that we were wrong on those and to get your money back on those various pieces. That is almost never an indefinite term. In fact, I would say, you know, sort of the standard, the norm that we're seeing right about now is anywhere from, I'd say, 12 to 18 months. If you can get 6, then you're killing it as a seller. If you are getting 24 or more, then you're killing it as a buyer. So negotiating that term of survival on the reps and warranties is a key component of the deal. If you're the seller, you want a limited escrow or a limited holdback. Again, you want money in your pocket now, not 2-3 years down the road. And you don't want the buyer to have too much control over how much they get to dip into that escrow account and take their coverage for any breaches of reps and warranties. You want a high basket on indemnification obligations, and what I mean by that is if you're the seller, you don't want to be having to pay for usually liabilities. You want to assume that you're going to have like $50,000 or $100,000, or it really depends on the percentage of the deal, until you have to pay one dime. So it's really, in effect, almost an increase in the purchase price that you're getting, but you'll say, okay, we'll indemnify you from any breaches of our reps and warranties, but we're not going to pay $1 until we get to $50,000, and then we'll pay everything over $50,000. And that's a really good thing because it gets the parties to not have to be nitpicking on the lower amount and to sort of build in a bubble there, just acknowledging that no business is perfect. Next one, you really want low caps on the indemnification obligations. So this is another one. It's pretty rare to see an unlimited cap on indemnification obligations. So what I mean by that is if you're the seller and you make all these reps and warranties about the business, the question is that going to be limited to a number, or is that going to be, you know, set, the sky's limited? You could lose not only what you get as the seller as a purchase price, but you could actually have liability beyond that. That's unusual. With the exception of the liability that goes on forever for a seller is oftentimes related to if the seller engaged in fraud or intentional misrepresentation or tax liabilities, things like that, then those are typical to live on and have them live on forever, number one, and then have no cap on them. For the rest of it, it's pretty normal. You pretty rarely see anything that exceeds the purchase price paid, but even more than that, there are market studies as to what a cap is on the indemnification, and I would say anywhere from 10 to 50% is sort of something that you might see as a sweet spot for the negotiations on an indemnification cap. Next one, if you're the seller, is you want limited non-compete and other fair trade covenant obligations, obviously. So if this marriage doesn't work out, you can go, the seller and the seller's principals and the seller's providers can get on with other options. And then, of course, if you're the seller, you want the cost and the time to complete negotiations. You want that to move quickly, typically. Buyer tips for negotiating a purchase and sale agreement. The buyer typically, but not always, provides the first draft, and that's expected in the industry. So if you're the buyer, then you want to take advantage of that because typically there are advantages to being the party that gets to put pen to paper first. Second tip, you definitely want the purchase price to negotiate downward automatically based on things that you might be finding in due diligence. And, you know, typically there is the ability to say we're not going to close and cause problems, but the way the deal is structured, a good seller with a lot of bargaining power may very well try to lock in a buyer and only have limited things that could either allow the buyer to get out of the deal or allow the buyer to negotiate that purchase price downward. So if you're the buyer, you're really focused on the ability to come back to the table and do counts of things that you think you're going to get or discounts based on what you might find in terms of financial reporting issues, all kinds of stuff. So building that into the agreement is a really important thing if you're the buyer. Also, if you're the buyer, you want very standard seller reps and you want them to come with an escrow or a holdback. It's pretty important if you're the buyer and you're buying from an entity or a group that's going to get paid and it's going to get distributed out to shareholders or individuals or up a food chain to another corporate owner, then there's nothing, you don't want to be in a position where you have to go back and sue worst case individuals to recover from breaches of the representations and warranties. So what you really want is an escrow, a pot of money where you can go back to it, you can dip in, you can say, we think you breached section whatever of the purchase agreement because there's this lawsuit that you didn't disclose, or there were claims of a lawsuit that you didn't disclose, and that ended up causing us to lose $500,000, so we're now taking that out of escrow. And if you control the money and control the basket that it's coming out of, you're in a far stronger position than you would be if you're having to go and sue individuals for that recovery. Next one, the mirror of the seller bullet is you want very low or no baskets on indemnification obligations so that you can start recovering from violation number one as opposed to waiting until they add up to $50,000 or $100,000 or whatever it is. You also want really high caps or no caps on the indemnification obligations. I think it's unusual to get no caps, with the exception of if you're seeing things like fraud or if compliance with certain, whatever it is, anti-kickback or STAR clause were critical to you, and you're saying no matter what, we're buying with the assumption that you were in compliance with these laws, then, and if you have any problems, you're going to pay for them. It's reasonable to negotiate no caps on that kind of thing. So you can pick and choose your no caps, but it's going to be hard to get a no cap on the entire sale. You also may want incentives for the management to stay or not, depending on how you're thinking about the management of the target. So building those in on the front end is a really good idea. It also is really important for getting them to sign on at the closing if they weren't part of, and they're often not, part of the letter of intent negotiation process. And then if you are the buyer, you want very broad seller non-compete, very broad fair trade covenants. You want them to last as long as possible. There are limits, as with employment non-competes. In some states, there are limits on what non-competes can be in terms of non-competes associated with the purchase or sale of a business. So that goes back to the state law issue and understanding what your limits are. The worst case is you may think you killed it because you negotiated a really, really long term for a non-compete, but you could have rendered the entire thing unenforceable by virtue of state law, which is a nightmare. So it's a very delicate balance of figuring out what your limits are under state law and then negotiating as far as you can go. In various states, it's not a big deal. The courts assume that what's being bought largely in a merger and acquisition is goodwill. So they say, yeah, you can have as long of a non-compete as you think it takes to recover that goodwill. Other states are not quite as friendly, and there still are limits, so you need to be aware of those. And then the buyer, of course, will want to focus on the facility lease assumption or purchase, because if that is a central component of a practice that is being added or consolidated, then figuring out that facility lease is going to be transferable and understanding the liabilities associated with it are really important. Similar, of course, to a real estate that's owned by the target. And, you really could have a real estate transaction within the broader business transaction, and it's easy to get a little lazy in those situations and not focus so much on the real estate deal when, in fact, the real estate could be one of the key assets of the business. So very important to have comprehensive provisions related to title and zoning and environmental stuff that could all come back and bite a buyer later down the road. Let's move now to employment and benefits considerations, as that was one of the things that was one of the main components that we put in our invitation. And as I mentioned, in addition to doing healthcare M&A, I also do employment counseling and employment advising in the healthcare industry. So there's a very interesting intersection because so much of the healthcare industry is really human capital. So you're dealing a lot, and the focus is very much in a healthcare M&A, what's going on with the workforce. And so it can become very much a central part of any deal, which is why I thought it would be good to talk about. Here's a checklist of things that I think should be front of mind as you start walking through. Really, I guess this is before you even put the deal together. But number one, are there going to be layoffs as a result of this merger and this acquisition? Is it going to be the case that the buyer's not going to want all the employees of the seller? Is it going to be the case that the seller has to lay off certain employees, or are we going to shift that to the buyer to have to employ them for a certain amount of time? Central to that is the next bullet, which is the Federal Worker Adjustment Notification Act that talks about how if you're going to lay off, I'll just use really rough terms because the WARN Act is complicated and layered, but if you're going to lay off more than 50 employees in any location, you need to be thinking about WARN pretty closely. And if you are, then those employees are entitled to 60 days notice that they're going to be laid off or 60 days pay at the time of layoff. And that can become, if you do the math, 50 employees, assume it's the minimum, times 60 days, that becomes a really big number. So thinking through that and thinking through what that liability is and ways to structure around it, and then shifting that WARN Act liability to whatever party you are not is the name of the game, so that you aren't paying for it if it happens. Next employment issue that's important to think about is the misclassification of employees and contractors. I would also put misclassification of, kind of central to this, but another issue is misclassification of salaried versus non-salaried employees, exempt versus non-exempt. These are really big liability pieces, and there's been a lot of focus on this, and I think we're seeing far more robust representations and warranties in the sale documents about employees and contractors because they've been getting tagged either in an audit, or you might have a whistleblower. Mergers and acquisitions themselves are often a point of time where employees are a little skittish. They get put into a new situation with a new employer, they don't like it, and then they're leaving, and now's the time that they decide to blow the whistle and say, you know, I was an independent contractor and I should have been an employee, or I was salaried and I don't think I meet the exemption test to be a salaried employee with this employer or with the one that I was with previously. So misclassification is really an important one. If that is a huge concern, if you're a buyer and you come in into a seller and you're doing a little bit of diligence and you're immediately your meter is going off saying something's not right here, we're seeing way too many of these, that's where I think a buyer is better served to call timeout and go do its own audit, because it kind of goes back to, you know, unless there's a really healthy escrow that you can dip into, and even then, you know, there are real huge disadvantages to having to deal with that and pay the penalties, and then the fact that people who get reclassified may be dissatisfied. So that's a huge interruption. That's certainly one where it may be worth doing extra diligence on your target to make sure that you think that for the most part they've gotten it right when it comes to classifying employees and independent contractors, as well as classifying exempt and non-exempt workers. Non-competes are really important as well. It's not enough if you're the buyer to just know that the seller has non-competes in place with its with its employees, the ones that you care about anyway, you need to see them, because non-competes are, as probably everyone has heard at some point along the way, non-competes are notoriously hard to enforce. They need to be really carefully constructed to comply with the state law in which the worker is situated, and there is a lot that can go wrong with a non-compete agreement. So if non-competes are central to a deal, then a buyer really needs to do its own diligence on those and get legal advice as to whether they're enforceable or not. If they're not, then there are certainly ways to deal with it. There can be new non-competes offered at closing in conjunction with new employment in some cases. There are ways to get around it, but it's all a little bit nuanced because, as I said before, non-compete laws are different in every state. So there's a lot to deal with if non-competes are central to the valuation of the deal. The next issue is immigration compliance. Obviously, this is a bit of a hot topic, but it's one that we've actually seen a couple times kill a deal or at least substantially delay it if the buyer has come in and determined that the seller was not doing a good job with immigration compliance. They may get worried about successor liability. So there are a couple ways around that. Of course, you can do more with reps and warranties and indemnifications of the seller to try to recover any of those breaches. Another way to do it is you can hire people, lawyers, or other specialists to come in and do an immigration audit of the seller. They can come in and they can look through the documents that are on file and determine how big the problem is and come up with ways to remediate it if possible. So there are ways to deal with it, but if you've got a large workforce in your target that may have immigration compliance issues, then it's something that can play a really key role in diligence and in negotiating to be aware of. Next one is extensive disclosures on pay and benefits. If you're the buyer, you really, really want to get more is the name of the game. So what you want preferably for your HR team is you want to get a schedule that has every single employee for the target that lists out, you know, name, what they're paid, what their raises have been, whether they have any agreements, what their benefits are, what their vacation banks are, what their health savings account balances are, everything under the sun. The more information you can get, the better, because that will really go a long way into the integration piece and figuring out packages that are going to keep those employees happy when they come to work for the buyer. And then unions. Unions are a really big issue as well. There are union liabilities that can extend for decades and can be very, very large. Obviously, if you're doing a merger and acquisition involving a union that has rights to comment on the deal, then that needs to be thought of very early in the process as well. Let's flip now to employee benefits issues, and these are, I think, the four big categories that I want to highlight today are the transfer of plans and an asset sale. It's not as simple as everyone wishes it would be to just transfer and buy a plan. It's typically much more complicated than that because of all the various ERISA requirements for each plan and how it's managed and the notification. So a transfer of plans is a big deal and needs to be thought of pretty early in the process to make sure that that can happen. In a stock sale especially, there's a lot of successor liability, so involving someone who understands ERISA law and can go in and help with the diligence on the benefits plan to identify any big red flags is really important so that you can figure out what to do about it or how to negotiate around it. Retirement plan liabilities are a big thing, and understanding those, especially if it's possible that the deal may trigger people, a larger number than would normally retire, to retire, or if there is a retirement plan liability that's unclear or hanging over the deal that needs to be nailed down, that can really be an issue. So trying to focus in, understand what those are, and then negotiate around them is really important. And then, of course, you have sort of, I'd say, a little bit of the softer issues, but employees are obviously really concerned about whether they get paid the same amount, but they're also very, very concerned and focused on employee savings accounts, so their health savings accounts, and whether they're going to forfeit them, which in many cases they actually are, especially if it's an asset sale. So that's a big deal. Vacation banks, no employees like to lose their vacation time. In most states, you can't have them forfeit it, so the buyer doesn't get to take a clean slate without the seller having to pay it out a lot of times. But even if you can do that, you can do that in some states, question whether it's worth it, because the employees are going to just be very unhappy to get this announcement that they're going to a new employer, and by the way, their 3 weeks of accrued vacation is no longer in play, or they're going to be eligible for much less vacation, so it can be a big deal. And then, of course, severance plans. So it's always a big surprise to a buyer at some point in the process when they learn that, the seller has severance plans in place, so that if someone is asked to leave, or maybe even if they leave voluntarily, they're entitled to some big severance checks. So dealing with that liability during the diligence process and negotiation process is really important. And finally, let's talk about integration, so after the deal closes. These are all the activities that have to take place after closing to assimilate. And I think that the importance of this really can't be underestimated. You can do everything right in the valuing and the negotiation and the closing process, and then get to assimilation and have the whole thing just fall flat, in which case every dollar that you paid just got devalued because things are not going well. So I like to give a little short checklist for things that the seller should be focusing on. One, sellers, especially the smaller practices, really need to accept emotionally that this practice is going to change. When they get consolidated or they're working with another equal, things are just going to be different. And to think that it's not, and even when they're told they're not, if they're getting bought and consolidated by a corporate consolidator or something like that, it will change no matter what. So the sooner the seller can come to grips with that, the better. It's really important for the seller to determine their role, if any, frankly, in the integration process. If there's confusion as to who's doing what and who's responsible for what on the day after closing, it can really lead to a lot of problems, and it gets things really off on the wrong foot for purposes of those indemnity claims for the next year or whatever. And then communicating that determination of the role to staff and colleagues is also very important as well. For the buyer tips, planning the integration is, like I said, almost more important than the purchase process itself. Helping the seller prepare for loss of control and trying to communicate what's going to change and what's not, and how the seller should be okay with those changes is really the buyer's responsibility. There are consultants out there who this is what they're brought in to do, is to work with the management teams and to understand and put forth a go-forward plan. If the buyer and the seller do not have the proper people to make this work and it's going to be oil and water, then I'd say it's worth it. And getting someone in there who can really help can be very, very valuable in the deal. The buyer needs to determine the pace of the integration and at what point people are going to be told. They need to implement the retention or termination of staff or colleagues in an orderly manner and have a plan for that and a communication plan for the people who are staying, since they may be demoralized by the people who are going. And then, of course, on-site integration team really from day one, and frankly, from day like -3 leading up to closing, it's really helpful if you can have a well thought out and well executed integration plan for the merger. And that's really all for a presentation. I really appreciate that everyone took their time to listen today. I hope it's been helpful. And as I said, I will do my best to respond to any questions that anyone wants to pose after we wind up here. But thank you all so much for attending, and please reach out and connect with me through LinkedIn or through email. I would love to stay connected. Thanks so much, everyone. Bye.